Hello and welcome back to the Civil Barrister channel with me, James Wilson from Park Square Barristers in Leeds. Today I'm talking to you briefly about the Debenhams case. Judgment from the Court of Appeal handed down on the 6th of April 2020, that was yesterday. This is a case which discusses the relationship between the coronavirus job retention scheme and whether an administrator adopts a contract of employment for the purposes of Schedule B1 of the 1986 Insolvency Act. And very briefly, in this case, Debenhams closed its doors on the 25th of March of this year as a result of the government lockdown, and it furloughed about 14,000 members of staff. On the 9th of April of this year, administrators were appointed. The purpose of the administration was to keep the company in a position where it could be sold as a going concern following the lifting of the lockdown. The aims of this administration were best suited by furloughing the vast majority of the staff and keeping some of the management in place, but to pay the furloughed staff only those monies which were recoverable under the job retention scheme. The administrators sought a declaration as to whether, by participating in the scheme, they were adopting the contracts of employment for the purposes of paragraph 99 of Schedule B1 of the Act. Now, obviously, the effect of adoption of the contract of employment in this situation is that the wages are payable as expenses of the administration ahead of pre-administration unsecured liabilities and many of the other costs of the administration. So the issue as to whether the contracts of employment were adopted or not is of importance to the administrators. This case followed a decision by Mr. Justice Snowden in the Carluccio's case. That judgment was handed down coincidentally on the 9th of April at the time that these administrators were appointed. And the administrators in the Carluccio's case asked a very similar question. They didn't get a definitive answer in the Carluccio's case, but they got some guidance. It was argued in this case, in the Debenhams case, that the contracts of employment had not been adopted for three reasons. Number one, that the furloughed employees were not carrying out any work for the company. Indeed, under the job retention scheme, they were not permitted to carry out any work for the company. Number two, that whilst furloughed, remuneration was limited to that which was provided for under the scheme. And the practical application of that is that the company was merely a conduit by which the money from the government got to the employees. And so it was cost neutral on the administration. And number three, any decision to terminate the contract of employment is postponed until after the scheme has ended. So those were the arguments put forward by the administrators. Not unsurprisingly, to my mind, the court found that the administrators had adopted the contracts of employment under the scheme, and it did so for three reasons. Number one, the administrators will continue to pay the wages of the furloughed employees up to the limits provided by the scheme. The employees' entitlement to that job retention scheme furlough payment is derived directly and exclusively from the contracts of employment. The payments are taxable and are an expense of the company, and the payment from the government to the company under the furlough scheme is an income for the company and is taxable for the purposes of corporation tax. The second reason is that all furloughed employees who have accepted the continuation of their employment by accepting the furlough payment schemes are bound by their terms of employment. And number three, in continuing to pay the furloughed employees, the administrators derive their power for doing so under paragraph 66 of Schedule B1. In relying on that paragraph, they must therefore be bound by the terms of it, and effectively they think that that by paying the furlough scheme, that's likely to assist the achievement of the purpose of the administration. In this case, by paying the furlough payments, that's likely to achieve the aims of being able to sell the company as a going concern following the lift of the lockdown. So for those reasons, the court was in no doubt, in my mind, that the administrators had adopted the contracts of employment. Interesting paragraph at the end of the judgment. Counsel for the administrators outlined the difficulties that may face administrators in deciding whether to take steps to retain employees under the furlough scheme, the difficulties of what will happen with holiday pay, etc., and the priorities given to that in the administration. The court accepted those difficulties, and the courts accepted the difficulties that administrators will be faced with, and I think had sympathy with the administrators in this case, as Snowden J did in the Carluccio's case, but ultimately forms the conclusion that if furlough payments in an administration are going to be excluded from paragraph 99 of Schedule B1 for the purposes of priorities, then that will require an Act of Parliament, and under the current law, that can't be done. So, as and until an Act of Parliament is put in place, furloughing employees for an administrator is adopting the contract of employment, and clearly that is a big issue which will go into the thought process of administrators and those who are advising them when they are appointed as administrators of companies with reasonable amounts of employees.